Everyone, we're back. On. Make sure your cameras are on, please. All right, let's see. Elda, where are you? Lydia, I see you. Brittany, where are you? Nina, Katrina, Jacqueline, I see you. Felix, back. Olga, Arlene, adjust the camera for you, please. Amy, where are you? Pedro and Vanessa. Lower the camera, lower the camera, lower more. A little bit more, a little bit more. Okay, good, right there. Perfect. All right. So, are there any questions before we start this next chapter? Do you have any questions you'd like to address? We're going to talk about risk management. It's 21-page chapter, but it should be something quick because we already talked about real estate market. We already talked about appraisals. We talked about investments. So there's a lot of stuff here that that we can skip through. Okay. Questions? All right, no questions. So we're going to move forward. Risk management. So when we talk about investments, one of the things that we said is that investment was risk, right? You guys remember that? Investment equals risk, right? Because every time you put time, money, or effort into something, you expect some type of return. For instance, when you wake up, you expect to have maybe a productive day, right? At least you have some type of expectation of the day. And you're probably like, Bruno, what are you talking about? This is risk management. Why are you talking about the day, right? Well, every time we wake up and get up, sometimes even staying in bed could be dangerous, but every time we wake up, get up, and walk, right? We are in some type of risk, okay? Now there's, again, low risk, medium risk, high risk activities that we'll take throughout the day. Obviously, we try to avoid the high risk activities, correct? Right? Some people love it. Some people go for, I'm daring but not too daring, so I'll do medium risk activities. For instance, if you go to work in a car, usually it's a little safer than going to the work in a motorcycle. Motorcycle will be like a medium to high risk. Car will be medium to low risk, right? If you take a bus, if you take a train, those have risk, but then they reduce the risk of breaking parts in your car, of changing oil and stuff like that. So they reduce the risk in other aspects. Are you guys understanding? So when we're talking about risk, any activity that we take could be a risk. Okay. So a risk is a chance of losing something. That's pretty much what it is. Risk is a chance of losing something. So its two dimensions are the probability of the occurrence and the extent of the exposure to monetary or non-monetary consequences. So again, risk. Something could happen. Are you ready for that, right? And if something does happen, how much is it going to cost you? So every time you drive your car, there's a possibility of eventually having to change the oil, eventually having to change a tire. There's a possibility of an accident. There's a possibility of a toll. There's a possibility. These are a bunch of things that could happen while driving, right? Are you ready for that? Those are the two sides of it, right? You go to work. What could happen bad at work, right? There's always risk. There's a risk of you getting fired. Are you ready if you get fired? There's risk. Do you have emergency funds in case you need to switch jobs or in case there's a pandemic? This is a great example of managing risk. A lot of people became unemployed and then no funds, right? No funds to survive. And look, this week, state of New Jersey, for instance, started paying out the remainder of that pandemic emergency fund. But was it enough? And how long were we without type of payment? You guys understand? A lot of people are now suffering because they never preserved their money. It was always the, hey, I got my job. I'm getting paid this. I'm getting paid that. So there's no worries. I'm safe. What about when there's none? What about when there's a health issue, right? And you cannot go to work. Look at my example. I just spent a week pretty much at home because I couldn't move, right? There's always the risk of, I had the risk, let me give you the example of you guys. I had the risk of one of you calling me and saying, Bruno, listen, I'm sorry for what you're going through, but I want my money back. Like, there's always the risk. And we have to calculate that risk every time we make any decision. You wake up, calculate risk. Very important. So the risk management structure approach to dealing with the uncertainties and consequences of risk, right? And in real estate practice, the aim is to reduce the risk to an acceptable level through anticipation and planning. Okay? So there's different risk management strategies, and this is the same thing that we teach in investments, and it's the same thing we teach in insurance, right? The concept is the same. Avoidance, reduction, transference, and retention. Okay? So let's start talking about these four. When we talk about avoidance, is I know if I jump off an airplane, right? I know if I jump off an airplane, there's two things that could happen. One is I forget to pull a cord, and there's certain death, right? Most likely. And two, I can pull the cord, and maybe there's something to hold on to me or hold me before I hit the ground, right? The parachute. But maybe we could avoid that high risk. Does that make sense? So avoidance is elimination. Is like, you know that there's a high probability. I mean, the ride is great. I haven't done it, but I want to do it. But the ride is great. Don't get me wrong. It's something I want to do. But should we avoid it? Right? How about reduction? Reduction. Why do we put seatbelts? Mitigating or reducing the risk. Here it says sharing. So sharing would be, for instance, if we get into investments, isn't it easier, instead of me putting $100,000 into a property, I put 10, you put 10, the other party puts 10, and so on, and between 10 people we reach the $100,000. So if things go wrong, what's the worst that can happen? We lose 10,000 versus 100,000. Do you guys understand? So sharing or reducing that risk. Transference. Transference is usually, we call it insuring. Transference is transfer of risk. If you get into a car accident, usually you have insurance to cover the chances of you getting into a car accident. If you do, they pay, and you just pay a small portion, which is your deductible, and then premiums might increase, of course, right? Outsourcing, like delegating. I'm not the expert at this, so what am I going to do? I'm going to refer to the expert. So I, again, transfer the risk to the party that's responsible for this type of action. So attorney, hey, law. Mortgage, hey, loan. Does that make sense? So transferring to the right party instead of retaining it. Okay? What should you retain? This is the last recourse. I'm sorry. What should you retain? The things that are unavoidable, the things that are acceptable, the things that we know might happen, right? So again, the cost of waking up every day is something that you know is going to happen. These are things you need to be ready for. So in our scenario, we need to spend money marketing. You know that. There's a risk that you will lose that money, like you won't make a sale, right? But you need to prepare. You need to accept the fact that you have to spend some money in order to conduct the business. So you have to budget yourself for that. Okay, so these are the 4 established strategies for managing risk. And I'm pretty sure, just in what I said so far, I'm pretty sure some of you are saying, I wish I knew this stuff when I was in high school still, right? Because you get to become an adult. Not in high school you're not an adult, but you're a young adult, right? But when I say you become an adult is when, oh damn, I gotta pay rent. Oh, I gotta get a job. Oh, kids, oof, where did these come from? What am I gonna do? All right, these are the things that while in high school you're thinking about. I don't know how you guys work, but in high school you're probably thinking about your friends that you got to take advantage now because you'll never see them again, or we're going to be friends forever, whatever it is. The parties. We're not talking about school because nobody cares about school. It's the parties, it's the friends, it's this is never going to end, right? And then as soon as high school ends, boom, life happens. Or you go to college, but then as soon as college ends, life happens. And by the way, here's a student loan. Here's debt for you to start your life. You know, so these are things that should have been taught to you right from the beginning. Some of you are smiling, so you know exactly what I'm talking about, right? Guys, start teaching youngsters. Start teaching, if you got kids, teach them. If you're an aunt or an uncle, teach your nephews or nieces. Start teaching, because they need to learn now somehow how to reduce these risks. They're going to happen anyway. But how to avoid, how to reduce, how to transfer some stuff, and how to deal with the ones you need to deal with. Now, not all of these strategies are possible or available, but a real estate firm or a licensee who fails to make conscious efforts to employ one or more of them increases the likelihood of loss from the many potential risks that are always present in the real estate business. So, avoidance means refraining from the activity that carries risk. So, you can avoid the risk of being in an automobile accident by not riding in automobiles. That's the example. Like I said, jumping off a plane, same thing. You can avoid it. Like, can you do it? Yes. It's high risk. Yes. Can I avoid it? Absolutely. Right? So let's go back to real estate. Complete avoidance of risk in real estate is almost impossible. See, a broker, for instance, may believe that hiring only experienced affiliates eliminates the risk that the affiliates will commit license violations. However, even experienced practitioners, and actually most likely experienced practitioners, may not know the law, and sometimes people break the law deliberately. Okay? Again, most of the times, the experienced ones are the ones that really do this. Right? So, the risk may be reduced, but it's there. As a broker, we know, as a brokerage, we know we're going to have the good, we're going to have the bad. Is there any way to eliminate it altogether? No. Reduction involves taking steps to reduce that probability or severity of loss. So in real estate, one risk reduction tactic is to share the responsibility for making a decision. The agent provides the consumer with expertise and perhaps some advice, but lets the consumer decide how much to offer. And in this way, the agent gets some relief from the risks inherent in the buyer's decision to purchase. Right? So we're not the ones that are going to sign the contract on behalf of the client. All we do in order to reduce this risk, all we do is say, hey, this appears to be the house that you're looking for. We have this one, we have that one, and that one. But it's your choice. The offers, I think this property is worth X amount of dollars, but it's your choice. You understand what I'm saying? So we are reducing that risk by relaying also that to the principal in this case. Now, transference, very similar to that, to what I just said as far as reduction. Transference is passing the risk altogether to another party, right? So by a contract or other means. Like I said, insurance. When you get in the car, right, there's liability insurance in case you make a mistake and cause an accident. There's insurance for that. For us, we also have insurance. It's called errors and omissions. So errors are mistakes that we make. Omissions is, I forgot to tell you. I'm sorry. Like, you see what I'm saying? I omitted something, maybe on purpose, maybe because I forgot it, because I was negligent, right? If it was on purpose, it could be deemed fraud. If it was fraud, then it's not covered. But errors and omissions, insurance. We transfer the risk or assign the risk to the insurance company. And as far as retention, like I said, is, hey, I know the risks. It is going to happen. But let's get ready for the consequences. So this is in effect self-insurance. And it's the only strategy left when the risk cannot be reduced or transferred. Okay? How can you manage the risk? Okay? Very easy. The first one, that's very, very important. First one that's very, very important. Education. So, if you didn't know, now you know. Biggie. But anyway, so, sorry, I always have to do that. So, education. The more you educate yourself, the lesser the chances of you making a mistake, right? Because now you know what to do. Education. Pre-licensing. What are you guys doing right now? I'm sure that it's giving you a better highlight, because I'm sorry, it's still not practice, right? So it's just theory. For me, it's called highlights of the real estate practice, right? So it's giving you a better highlight, a better understanding of the real estate practice. Can you now say, you do not know? You can't. You might not remember, but you cannot say, I do not know, because you've been through the education, right? The other side of it, to manage your risk, is disclosure, right? I told you guys, anything and everything that could affect the proposed transaction must be disclosed. So the more you disclose, lesser the chance of you getting injured in a transaction, okay? Of course, keeping proper documentations and record keeping and insurance was the final one, okay? So education, we covered. Pre-licensing, continuous education, specialized courses, right? Disclosures. These are the disclosures that are very important. Agency relationships. We just talked about it in the previous chapter about who's the client, who's the customer, right? I could represent as a seller's agent, as a buyer's agent, as a disclosure agent, or even as a transaction broker, right? So I don't represent you, I represent the transaction. Disclosing the property condition, this is what it has. Duties and obligations, so fiduciary duties, we went over this. So disclose what they can expect from you. Again, as I said earlier, if you have a personal interest in a transaction or personal interest in the referrals. Keeping proper documentation, listen, I love putting things in writing, right? Keeping proper documentation. Because then we don't have the he said, she said scenario, which in court, it's literally called hearsay, right? It's called hearsay, and hearsay does not have weight, as much weight in court as factual. And factual will be by holding proper documentation, okay? So keep records, because then you can say, hey, no, it's not he said, she said. No, it's right here. Boom. Your Honor, this is what it was. Right, it's right there. Documentation. And that's why in the real estate business, we must keep documentation for X amount of years, right? Again, some documentation is required by law. For the agency, there must be policy and procedure manuals. So standards of conduct for the office. There's the state regulations, and there's the National Association of Realtors standards of conduct. So those go with policy and procedure manuals. You guys already learned, but you're going to learn again when we get to the New Jersey portion, that there's standard forms that must be provided. So it's easier to just say, hey, fill in the blanks, because the laws are clear and widely known, and this is the form you need to fill out, period. Keeping communication records, so phone calls, messages, emails. Guys, I have here about 10 years, 10 years of calls and messages. And it's only 10 years, well, a little bit less than 10 years, but it's only 10 years because I made a mistake 10 years ago when I was changing from a phone to another. I made the mistake of not saving the messages or calls. And that's why those were deleted. Otherwise, I would have kept them since 2001 when I came to the United States. I would have kept all the records, right? And I had them all, again, when I switched from BlackBerry to Samsung. I had everything transferred. And then a couple years later, unfortunately, I forgot. Big mistake. But I forgot to save. So, lost it all. But anyway, I keep everything, right? So then you can tell me, Bruno, you did not. Oh, whoa, whoa, what do you mean I did not? It's right here, right? If I did not, I'll own it and I'll tell you I did not. But if I have records, oof, nope, that's it. You're in trouble. And usually that's how I win stuff. I have documentation of everything. And Jacqueline's like, yep. All right. Transaction records, keep them. Contracts, accounting, and other important documents. Keep records of everything. That's your protection. Okay? Standard forms. These are some of the standard forms that your brokerage should provide to you. So buyer and seller representation agreements. Like I said, we have a disclosure form for representation. Agreement to show property. Purchase and sale agreement. Agency disclosure form. Property condition disclosures, this is for the seller. Lease agreements, personal interest, if you are a realtor that's selling your own home or somebody that's close to you. Referral for service disclosure form, lead-based paint, other disclosures like for mold, radon, and so on. Referral agreements, independent contract agreement between you and your broker, and a checklist. We have a buyer's checklist. We have a seller's checklist. So depending on who you represent, there's different things you need to do. Okay. So these are just some examples of standard forms that must be provided to you. Transaction records for you to protect yourself. Again, not only your text messages, emails, and phone calls, right? Because the phone calls don't show what you said. Text messages and emails do, but at least shows there's a record of a call and conversation, right? That's this one. But you have to keep copies. So here in the state of New Jersey, 6 years. They say national says it could be 3 to 5 years, but here we go an extra step is 6 years, as an example. But keep copies of the listing agreements, all the offers, contracts, closing statements, agency agreements, disclosure documents, and so on. Keep records of everything. Accounting. Keep records of the deposited information. Date of the deposit, withdrawal of the monies, right? Who did you pay out to, whatever money you withdrew from the account. And then other information deemed pertinent by the Real Estate Commission. So again, state of New Jersey also requires that you keep 6 years of these records, as an example. Okay. Insurance, we have different types of insurance, as you guys know. So there's the general liability. This is usually for the property owner. They have let's say they have here for the business. We have business liability, we have workman's comp, and we have errors and omissions insurance. So these are different types of insurance. For the business liability portion of it, it insures any slips and falls from the customer here in our facility. And it ensures any loss of business, anything like that, right? The workman's comp is because we have our employees, which are the independent contractors, and the employees themselves, like a receptionist or anything, while conducting business on behalf of the company. If anything happens, slip and fall by the employees, it's covered. And then again, errors and omissions. If you're not professional enough dealing with the customers and we get sued, we're covered, right? What they do not cover, none of these types of insurance, what they do not cover is violations of the law, okay? fraudulent or dishonest and criminal malicious acts, mishandling of escrow monies, earnest money deposits or security deposits, sexual harassment, fair housing violations, agent-owned properties, environmental violations, failure to detect environmental issues, so something that you were negligent, you just didn't pay attention to. Acts that were prior to license or after termination, and activities of an appraiser as an appraiser if licensing other than real estate required. So if you act as an appraiser and you don't have that license, does not cover either, okay? So in short, E&O covers mistakes, not crimes, okay? Got it? So E&O does not cover the mistake of traveling while in class. No, not cover that mistake either. Good? There's a fire hazard insurance. It's for property owners. There's a flood insurance if the property is located in the flood zone. These are the other types of insurance that we just talked about. Workman's comp, for instance. There's casualty insurance for vandalism, burglary, illness, and so on. There's contents and personal property. Consequential loss for the use and occupancy, so hazardous. Surety bonds, and so on. These are different types of insurance. You guys have any questions before moving forward? Kieran, do you have any questions? Since Brittany's not paying attention, do you have any questions? You guys forget that I'm always looking at the screen. I'm not reading the book, I'm looking at you. Terrible. You are a bad example, Kieran. Bad example, I already told you that. Love you too. All right. Guys, any questions before I move forward? Cool. So until now, I think everybody knows pretty much this. Insurance, managing insurance, right? Managing risk. So, agency. What are the risks of an agency? First of all, what is agency? Who can tell me what is agency? Let me know in the chat. What is agency? What does it mean, agency? Guys, what does the word agency mean? And Nina, for the win. Employer-employee relationship. That means you got hired and that created an agency where you became an agent for someone. You're representing someone. That's agency, right? So here's the issues with, or the risks of agency. The requirement to inform and disclose, and the requirement to carry out the fiduciary or agency duties. Okay? So there are risks. Under the disclosure requirements, remember that you have to disclose anything and everything that will affect or could affect the proposed transaction. So if I'm acting in a transaction as a facilitator, agent, sub-agent, designated agent, single agent, dual agent, or non-agent, some capacity. Regardless of it, I still must follow the disclosure requirements. And these are, again, to disclose verbally and then in writing who am I and what you could expect from me. That's what it is, okay? Confirm that disclosure in writing, like I said, before presenting an offer. Get a signed receipt that they received that disclosure for agency. Carrying out the duties of agency also require disclosure of personal interest that I have in the transaction. I just covered that earlier. Personal benefit that the agent will derive from a referral service, so I have to disclose that as well. Required property and market information, and information about customers that a client is entitled to have. Like for instance, I represent the seller and the buyer does not qualify for a mortgage. Should I tell my client, hey, they don't qualify? Absolutely. So that's something that must be disclosed, right? Your duties as an agent to all parties, right? Duties to all parties, regardless, is to be honest, fair, have a certain or reasonable degree of care and skill, so knowing what you're doing, and holding proper disclosures. To the client, I have here in green, to the client, skill, care, diligence, loyalty, obedience, accounting, confidentiality, accounting, and full disclosure. This is cold. Cold is care, obedience, confidentiality, and loyalty go right here. So this is loyalty, disclosure, accounting, and then skill and diligence go under care. So if you guys remember, care, obedience, accounting, loyalty, and disclosure, that's what this is. Okay? Cold. You represent somebody, you got to have a cold. Care, obedience, accounting, loyalty, and disclosure. Those are key. You got to care enough to gain the proper skills and do the due diligence, so not be negligent, right? You have to obey lawful instructions, so obedience. You have to hold proper accounting of their money. You have to be loyal. If they tell you, you got to be loyal. If they tell you they're selling the house because of divorce or anything like that, you have to be so loyal that you keep these things confidential. You don't pass it along to the other party unless your clients told you to do so. And D, for disclosure, there must be full disclosure, again, of anything and everything that could affect the proposed transaction. Okay? So I cover that. Okay. Right? Next thing. Depending on the state, the licensee, and guys, I'm on page 364 right now. Not quite sure what page will be on the first edition of the book that you have if you have the physical book. But depending on the state, the licensee may have no further duty to disclose property condition after the property properly informing the parties of their rights and obligations. However, the licensee may still be subject to legal action for deliberately distorting the facts, that's intentional misrepresentation or fraud, like cheating at a party, concealing or failing to disclose adverse facts that the licensee knew about or should have known. So it could be intentional or it could be unintentional misrepresentation. So look, we closed, right? You got your house, I got my money, I walk away, right? No. Whatever you did in the transaction could still come back to haunt you. Again, depending on each state, it could be 3, 5 years. Here is 6 years in New Jersey. For the next 6 years, anything you did wrong in a transaction can still come back to haunt you. So be very careful with how you conduct yourself. Make sure you're managing your risk. Disclosures for hazards, for instance. You already know if the property was built before 1978, there's a high chance of lead-based paint, right? If there's lead-based paint, you got to let the buyer know, listen, potential lead-based paint, because the property was built before 1978, you have the right to inspect the property, right? Other disclosures could be, if you know about these things. If you don't know, then you ask for an inspection. You ask the buyer to conduct an inspection. So termites, the soil tests, see if there's any, if you're in an area where there's subsurface sewage disposal versus the city sewer. Impact fees or adequate taxes, disclosure, mold, radon, and so on. So things that are discoverable, most of them, by doing a home inspection. Okay. CMAs, I just told you guys, the CMA, and I know I'm going right through it, like I said. Risk management is knowing everything you guys already know and avoid certain things. Like in CMAs, comparative market analysis, you cannot misrepresent yourself as an appraiser because you're not an appraiser. What are you? You are a salesperson or a broker. So what can we do? We can do CMAs or comps, but we can never do appraisals. Appraisals are for a fee, and CMAs or comps, most of the times we do it for free. While Felix is typing, what is the difference between free and fee? While I have Felix typing the question, what is the difference between these two? Who can tell me in the chat real quick? Felix, so if you check a house for potential hazards during the transaction and see nothing, do you still need an inspector? Well, because you're not a professional, what do you think you should do? You should always recommend the client to get an inspection. All right, let's see. Amy says, well, fee has a cost. Okay. Guys, what's the difference between free and fee? Aye, aye, Captain. The R. Okay. Brittany, are you laughing because Kieran gave you the answer? Or no? Because the answer is exactly what Nina said. The difference is the R. Why is this so important? Now, Amy, you are right, okay? You are right. If it's a fee, there's a cost. If it's for free, there's no cost, right? But why I'm addressing the R as a difference? Because when there's really tiny letters, and you're speed reading through that question, okay? These two, let me make it even tinier. These two look very similar. If you're speed reading, because there's more stuff attached to free, here it's easy to identify because they're isolated from the rest of the text. But when we're reading with a bunch of other stuff and it says fee or free, if you don't pay attention, that R, that little letter, changes the whole meaning of the question. And sometimes, so yesterday in my evening class, some students were asking, oh, I did the practice exam and I failed in this question or that question. As soon as they start telling me what the question was, I start addressing the issues. And I'm telling you, the issues, as I explained to them what the answer was, the issues were almost always because you did not read. For instance, there's keywords. This is one of the key words. All of these except, right? So there's questions, there are all of these except, and give you 4 options. Or the other one is, which one of these is not something? And they'll put the options there. Sometimes we talked about federal laws, we talked about state laws. Sometimes they say, like I was going over yesterday, sometimes they say under, and sometimes they even put in big letters, under federal law. What can you do or what you cannot do, right? All of these are allowed except under federal law, something like that, right? And most of the times the mistake was literally either not seeing that they're asking about federal law and not state law, or they did not see these. Oh, it's the except. Oh, it's the not, right? Oh, it's the comma. Oh, it's the R that's not there. So these are key things to pay attention to, guys, when you are taking the exam. These are key things to pay attention to. One tiny letter, one comma could change everything. So that's why I usually say that you got 4 hours, guys. You got 4 hours to complete the exam. So take your time, read the questions, pay attention. Okay? So again, can you represent yourself as an appraiser? Can you represent your comp as an appraisal? No. So can we say, hey, we're going to do free appraisals? Nope, we cannot. Okay. Covered all this, covered all this. Okay. Unauthorized practice of law. So we are on page 366. Unauthorized practice of law. What does this mean? It means you're not a lawyer. You're not an attorney. So why are you giving legal opinions? That's pretty much what it means, right? So if somebody asks you, oh, if I do it this way, is it legal? If I do it that way, can I do it? I don't know. Let's ask the attorney. Okay, so do not get yourselves involved in legal practice without having a license. Okay, that's pretty much what it says. For contracts, we're allowed to fill in the blanks on pre-printed contracts, right? Because all we're doing, again, is pre-printing, we're filling in the blanks on the pre-printed law. So we're not altering what is law or what is the contract. We're just entering the information to complete the contract. So that's okay. All right, so never give legal advice. Advertisement, you guys already know, based on the fair housing, based on discrimination, you cannot just say whatever you want. You have to be very careful with your advertising. There's steering, blockbusting, there's a bunch of that stuff that could cause a lot of problems for you. All right, right here at the end of page 368. We already mentioned this before, but I mentioned it again, which is the Sherman Antitrust Act and the Clayton Act. The most common one that will be in the question for state exam is the Sherman Antitrust Act. So most states have this rule. New Jersey clearly has this rule. We're going to talk about it again, which is everybody's entitled to negotiate the fees. There's no standard fee or flat fee stipulated by the government or by any other agency, right? And the individual agency cannot stipulate standards and tell the client, this is what it is, across the board. No, all right? Every client's entitled to negotiate it. So it says right here that the Sherman Antitrust Act makes illegal all contracts, agreements, and conspiracy among competitors that would unfairly restrict the interstate trades by fixing prices, rigging bids, or other means. So what we're saying is I cannot go to my competing companies and say, hey, let's make this a standard. This is the standard commission from now on. I cannot do that. That would be creating a monopoly. That's unlawful. And it's only $1 million fine, 10 years in jail. No biggie. You have to pay the other party also the 3 times the damage, plus legal fees and court costs and all that stuff. So no biggie, right? So go ahead. Tell them the commission is 6%. Go to the office across the street and say, hey, Weichert, 6%. That's it. Let's make it a standard. No competition here, right? Can't do it. So these are the antitrust acts. All right. Rules and regulations, state laws. We already covered all this as well. If you don't comply with any of these rules that we just went over, you could lose your license. They could revoke it or suspend it. They can discipline you somehow, or even you could get sued for damages. If your license expires, it's probably because, or if they let your license lapse because you don't have E&O insurance, so your broker did not renew it for you. You might not meet the the education requirements, or observe the correct renewal procedures. That's the easiest one to fix. Okay. If it's license revocation or suspension, it could be because you were found guilty. Okay, so it's not because you were arrested, right? It's not because they suspect of it. It's because you were found guilty. So you're convicted. You were indicted. Like there's a resolution that says you are the person that did this, right? So, for instance, you obtained the license under false pretenses, meaning you said you were one thing and when you're actually another, or for one thing and then it's for another. Committing any of the prohibited acts, we'll talk about those later. Neglecting to present every written offer as required. You guys notice it says every written offer. So if my client says, hey, I don't want any offers below $100,000, okay? Is your job to reject offers below $100,000? No. Your job is to say, client, I totally understand, but by law I still have to present all offers, because the offer could be $1, but then there's other clauses to it that make it $100,000. So guys, for instance, if it's a lease option, so let's say I'm going to buy your house and I'm telling you, hey, it's $1 now for the option to buy in the future. You guys understand? Still has to be presented. Regardless, all written offers must be presented. Written offers. Neglecting to deliver signed copies of accepted offers to the transaction parties as required. Okay? Failing to make sure that all required terms and conditions are present in a contract to purchase, or the most common issue, handling monies. If somebody gives you money towards a transaction, what do you do with the money? You go to a casino, right? That's what we should do, right? Or you go spend it in a nightclub. That's what we do. All right, no. Plus, nightclubs might be weird by now. I don't know. Has anybody been to a nightclub recently? No? Bar recently? Nobody? All right. I just think that it might be weird right now. It might be a different vibe, right? Gotta be constantly some shots. There you go. You have a trade-off between the mask and the shots. Must be funny. All right. Licensee discipline. A state real estate commission may assess civil penalties. So costs for violations of a statute, rule, or order. Licensees are disciplined for acting without a license when the license is required, demanding a referral fee with reasonable cause, without reasonable cause, entering into a net listing. Most states outlaw net listings. Trying to induce another licensee's client to end or change an existing agency contract. Paying a commission to an unlicensed individual. So none of you are licensed right now, but you refer business to me and I pay you. That's illegal. Once you're licensed, you can get paid. Until then, I appreciate the referrals. That's all I can say. Receiving an illegal referral fee, rebate, kickback from another professional, or practicing with an expired license. It expired, you can't do anything. Okay? Lawsuits that could happen against you if you violated fair housing laws, discrimination, right? Antitrust violations, so that's monopoly. So the Sherman Antitrust Act or the Clayton Act, right? If you violated the license law and other state law violations, if you breach the contract as an agent, if you breach your duties as an agent, if you practice law illegally. It keeps on repeating everything that we've been talking about in this chapter, right? Keeps on repeating over and over. Failure to disclose again. Customer client dissatisfaction with your services, any fraud or theft. So you could pay penalties for any of these. Now, what is misrepresentation? Let's slow down for a second. What is misrepresentation? Misrepresentation is you're saying, right? You're going to say that this right here is green and this right here is pink. Now, it's clear that this is blue and it's clear that this is white. But you're making a misrepresentation of what it is, right? I mean, you're saying that it's something that it's not. It's called misrepresentation, right? It's the same thing as me telling you this is, my wall is like this when it's not. This is just the screen of a computer. My wall is actually this color, but removed. Anyway, so it's making a statement that is not. Okay, so that's what misrepresentation is. And misrepresentation could be done unintentionally or intentionally. If it's unintentional, you might not have to pay for whatever you caused. You might not have to pay. If it's intentional, then it's fraudulent, and you definitely have to pay for it, right? So under unintentional misrepresentation, there's two different types of unintentional misrepresentation. There's the honest or innocent misrepresentation, and there's the negligent, or you're just being careless in your job. That's what it is. So this type of representation occurs when the licensee unknowingly conveys inaccurate information to a consumer concerning a property, financing, or agency service. False or inaccurate information that the licensee as a professional should have known to be false or inaccurate may be included in this definition. Those found guilty generally have to pay fines and may be disciplined by the state real estate regulators and other professional organizations. What are the risky areas for unintentional misrepresentation? Making and reporting measurements, describing the property, offering opinions about future growth and development of a neighborhood or a neighboring property, making declarative statements about the presence or absence of hazardous materials. How can we reduce this misrepresentation? By learning to measure and calculate areas accurately, right? By relying on measures reported by others, only with extreme caution and specific disclaimers, refraining from exaggeration, right? Some people cannot do that, unfortunately, right? Avoiding stating opinions of consumer that a consumer might take for expertise, right? So you can avoid the unintentional by following these practices. If it's intentional, then it's fraud because you know what you're doing. So intentional fraud, you know what you're doing. Okay? Insurance does not cover fraud. Remember that. There's another risk that we have. There's another risk that we have, guys. Recommending providers. Can we? Can I recommend, hey, this is the attorney that I like to work with. This is the title company I like to work with. Here's the mortgage person if you don't have one. Can we recommend? Could that be a risk? Could that affect you? Could that bite you back later on? Yeah, absolutely. Because if they're unprofessional, they're your referral, and your client could say, hey, you're the one that caused the damage because you're the one that said they were good, right? So could it be a problem? Yes. So there are several risks attending the recommendation of vendors and service providers to a consumer. First, the consumer may not be satisfied with the performance of the recommended party and blame the licensee. Second, in cases that there's a recommended provider performs illegal acts, there may be legal consequences for the licensee. But I have nothing to do with their illegal acts. You're part of it. Somehow, you're referred. Third, if a licensee has a business relationship with a recommended vendor or provider and neglects to disclose the fact, there are license violations. What is a business relationship? Again, I might get paid, there's a business going on, I might get paid from this provider. So one thing is, I recommend the mortgage person. Another thing is, this mortgage person or their company pays for a rental of an office space here. Let's say I have a small office space and they rent it here. There's a business relationship. So I'm receiving some type of compensation. Not a direct compensation like, here's a client, pay me for it. But we have an ongoing business relationship because of that rental within the office. You guys understand? So there's an interest. So very careful with that. The major risk management technique is to shift the responsibility for choosing a vendor to the consumer. And this can be done by refusing to recommend. So if you don't want that liability, hey, listen, no, go find your own, right? what's the drawback? What's the drawback of saying go find your own mortgage rep, your own appraiser, your own attorney, your own? What's the drawback of saying, hey, you do that, I'll just consult? What's the drawback? Most people, most buyers and sellers, they want to be treated like babies. Like they want you to carry them, right, all the way through. So if they feel that you're not willing to take that extra step and they do not understand these rules, right, that we're just going over, they can feel that you're not professional enough to serve them, right? So that's the drawback. So if you want to reduce the liability, just avoid the recommendations, right? But you can always tell them, right here, to the best of my knowledge, they are professionals in their business, but that's as much as I can tell you. It worked fine with other clients that we've worked with, but I cannot vouch 100% that they will be the best ever. You guys understand? So now you're reducing that liability by making that statement. Now, again, should you recommend providers? I think so, because usually I have the team that I work with. Usually I have the mortgage professional, I have the title company, the attorney, home inspectors. I have everybody in-house, meaning the people that I work with are people that I know and trust. And my transactions will be smoother because I use these people. Usually that's the pattern. If somebody does something wrong and I get to find out about it, they're off the team real quick, right? I don't play games with that. I'm not gonna, oh, let me give you another one and give it a try. No, sorry. Correct whatever you need to correct, and then when you're ready, come back. That's it. I'll keep on referring business, right? But I want my customers or clients satisfied. That is key to me. For several reasons. One of them is I don't want to get sued by my clients, right? For bad recommendation. Okay, and the second reason is we want to close. We don't want to have problems along the way. Simple. Discrimination, you guys already know that it's illegal to discriminate, so you can't discriminate moving forward. Keep a reporting of the progress, so always talk to your clients. Qualifying the buyers is not you, it's the lender. Appraisals, we talked about earlier with a question that Nina had right in the beginning. RESPA violations, we talked about these as well. Right? We talked about these when Felix was asking, hey, what's an H-24 and H-25? No, we don't need that, but you need to know what a loan estimate is, and you need to know what a closing disclosure is. So we just talked about that yesterday, right? Forward. Handling escrow money. Guys, we also covered this. Handling escrow money, you got to be very careful with other people's money so you don't commingle or convert. Remember commingling and conversion? What do they mean? Commingling is mixing of other people's monies with your business or personal funds. And conversion is using the monies that don't belong to you as if it was yours. Okay? So state laws prohibit you from doing these things. So again, a lot of repetition. See? Commingling and conversion. We just talked about it yesterday. All right. Does anybody have any questions? I know I went right through it, but again, it was more like a review than a actually detailed chapter, because we talked so many times about every single aspect here. I didn't feel like I needed to go detail. So I'll open now to questions. Questions. All right, Amy has a question. There you go. Felix looks like he's typing, but did not put the question mark, so I'm not going to address his question. Brittany, do you have questions? Brittany, questions. Arlene, question. Olga, question. Trina, Jacqueline, Elda. Any questions? Vanessa, I know you're listening. Questions? Vanessa, I know you did the Dearborn chapters. This was not there, but this helps understand it too. Okay. All right. Where is the deposit of escrow held? So escrow is a third-party account. So it's an escrow trust account. It just has to be held in an authorized financial institution. So whatever the state of New Jersey or the state of New York or the state of Pennsylvania deems to be an authorized financial institution, it's a separate account that every brokerage must open just for these escrow deposits. That's what you need to know. Okay. As far as telling the client that you don't guarantee 100% of the work, do you need to put that in writing? So we are creating, as an example, we are creating a disclosure form for that. Like anybody that we recommend, they are their own professionals, they hold their own licenses, and we do not guarantee 100% their work. So we put a little disclaimer that says, hopefully they're good. That's what we expect them to be as professionals, right? That's the reason why we recommend them, is for that. But don't hold us liable. It's almost like a hold harmless agreement. Like, I recommend to you, choose to go with them, it's on you. That's it. It's like a Craigslist or Amy's list or whatever the other, Angie's list, I'm sorry. Not Amy's, sorry Amy. Angie's list or something, that you have these professionals. We're recommending the professionals because they're part of the network, but they have their own individual licenses and they're individually liable for anything they do wrong, not us, right? So some type of disclosure like that should be presented. Can you put the disclaimer on the disclosure form? Which disclosure form? The one I'm telling you? Yeah, well, that what the disclaimer will be. So it's disclosure of business relationships. Is the disclaimer of the type of professional that you are and that they are, and that you should not be held liable, and that the client or customer acknowledge that. Yeah. Would an escrow account fall under a business account, or could be a regular checking account? I'm not understanding your question because, Nina, a business account or personal account could be escrow account. It just depends on what you're doing. In this case, it has to be a business escrow account, right? So it could be there's checking accounts, there's savings accounts, there's escrow accounts, all that stuff, right? But there's business checking accounts, there's business saving accounts, there's business escrow, and so on. So in this case, it has to be an escrow account that's open by the business for the purpose of holding other people's funds. Just that. Okay. Question? Questions? Can I give examples of unintentional fraud in real estate? So there's no unintentional fraud, there's unintentional misrepresentation. Because fraud is intentional, right? So let's correct that for this purpose, okay? So there's intentional misrepresentation, that's fraud. Unintentional misrepresentation is, oh, the seller told me the roof was 5 years old, right? So when you told the buyer the roof is 5 years old, you were relying on what the seller said. It's not your job to go inspect or know about the age of the roof. So your representation was innocent or unintentional because somebody told you. Somebody that's the expert in that told you. The other type of unintentional or careless or negligent misrepresentation is there's some type of spot in the tile in the drop ceiling, but you did not pay attention to. So you were negligent. You didn't do it on purpose, so it's unintentional, but you were negligent by not looking around and seeing that there's damage. And that damage could mean a leak on the roof or a pipe or something. So unintentional misrepresentation is you did not know because somebody told you and they're the experts, not you, right? or you should have known. These are the two options. You should have known, you just didn't do your job. So it's unintentional. It could lead to license and financial repercussions, or not, depending on what you did. When you receive a statement saying you have an increase of $650, and it's coming, oh, okay, you're talking about the annual statement on your, on your mortgage, exactly? Yeah. So it means that either the taxes, the property taxes, or the insurance increased. Because remember, your principal and interest, if it's a fixed rate loan, your principal and interest does not change across the board. But taxes change yearly, and your insurance could change as well, your insurance premiums. So if you saw an increase of $650, it should say there exactly how much it is in the statement. It should say it was the taxes. So look for the second page or the third page of that statement, and it shows how it used to be the taxes and what the taxes are now, or what used to be the insurance and what the insurance is now. Okay? Even though not related to the class, this advice is free of charge. Amy, so an escrow account temporarily holds the funds until closing. Or if we don't close until the transaction is done and we have to refund the money. Yeah. So the escrow account is for those people money, so it doesn't belong to you at the brokerage. So I give you the money. If we close, that money is now credited towards the closing, towards the down payment. If we don't close, it must be returned to me. So ultimately, yes, it's for temporary holding other people's money. Yep. Question? Once, twice, twice and a half, twice and 3/4. Sold to the fact that we have no other questions and we're going early break for lunch, and Nina disappears. All right, Nina, what's the question? Go ahead. I know you're joking. You do it on purpose every time. I know. All right, guys. So if there's no other questions, I wish you guys an amazing afternoon. If you want to see us at 5:30, we're going to have chapter 30 and potential start math already today. So if you want to join us for that class, you can. If not, I'll see you tomorrow at 10 a.m. Thank you, guys.